As many come to know later in life, California is a community property state, which means that property obtained during a marriage is presumed to be community property of the marital estate. But what happens if the property was obtained in another state under different laws and titled in just one spouse's name? The 1965 case of Addison versus Addison examines this question in the context of a divorce proceeding in California. Leona and Morton Addison married in 1939 in Illinois. 10 years later, they moved to California, bringing with them approximately $150,000 in cash and personal property in Morton's name that they had amassed as a result of Morton's various business pursuits during the marriage. In 1961, Leona filed for divorce in California trial court. She cited Morton's adultery as grounds for the divorce and claimed that the property in his name should be distributed as community property in accordance with California's quasi-community property statute. The law provided that property held by one spouse as separate property would change to community property if it would have been considered community property had the spouse been a California resident when the property was acquired. The trial court determined that California's quasi-community property law was unconstitutional and that any property titled in Morton's sole name was his separate property. The appellate court affirmed the trial court's decision, but also noted that any question as to the constitutionality of California's law was most aptly addressed by the state Supreme Court. Leona appealed to California's Supreme Court.